Hello, it's Saturday, June 6th. This is part 5, and this is Judge's Orders. So on my website, there's a section in the Curtis Wright case that's called Judge's Orders. So these are all the orders that were issued by the presiding judges over the Nelson versus Curtis Wright case. So the initial judges were District Judge David H. Norton, and the magistrate judge was Molly H. Cherry. On October 7th, the judges were reassigned. So the district judge was Richard M. Gergel, and the magistrate judge became Mary Gordon Baker. Since October 7th, this case has suffered tremendously because of judicial bias, the judges aligning themselves completely with the defense counsel. All the rulings that I filed have been denied, even with supporting evidence. The judge has denied it. The judge is disregarding legal standards, making orders that disregard the law completely. It's ECF 192, which is docket number 192. The judge issued an order stating that the subpoena that was issued by the previous magistrate judge, Molly H. Cherry, in the order it said that I was mistaken, that the court didn't issue a subpoena. And they based that decision on ECF 73, which is docket number 73. The backstory with that was I filed a lot of documents asking for subpoenas to a lot of non-parties. That also being my former attorney, Bonnie Hunt, Microsoft, Google, Verizon, Honda, Motorola, to gain evidence in support of my cyber intrusion claims, to gain evidence in support of possible bribery with my former attorney, Bonnie Hunt. The judge denied it, stating that it was too much evidence or it was just too much. So I condensed it, refiled it, and Magistrate Judge Cherry approved it in docket number 80, ECF 80. So she approved the subpoenas. I was issued signed subpoenas by the court. I was also issued a signed subpoena for Bonnie Hunt that was issued by Magistrate Judge Molly H. Cherry. So when the reassignment occurred, Magistrate Judge Mary Gordon Baker, she issued an order invalidating the subpoena. Another judge can't invalidate a ruling of a previous judge, and with no explanation. The only explanation they have was I was mistaken. The court didn't issue it. Okay. I filed a motion for recusal because at that point it was obvious that the judge was aligned with defense because that ruling made absolutely no sense. I filed a recusal, which was ECF 199. It's listed under plaintiff filings, which is me. And in that recusal, I filed a copy of the subpoena that was issued by the court, and it's Exhibit E in ECF 199. So the actual subpoena that was issued to me by the court has the court's seal on it and a date. That's not something that I can duplicate. So her ruling stating that the court did not issue me the subpoena was false. And it was proven by the subpoena that I filed in my motion. But it made no difference. She continued with her ruling. So that in itself was enough grounds for me to file for a recusal, but she can choose not to recuse herself. And that's what she did, because I filed 3 motions to have her recused from the case, and she denied all 3 of them. I believe Judge Gergel denied one of them as well. So basically, this case has been an uphill battle for me because it's not based on any fairness. It's not conducting itself in accordance with the law. The defense counsel is continuously breaking the law. There's obstruction of justice, denied access to the court. There have been instances where I filed something with the court and it didn't show up. So I filed a notice 8 days later. It was November 14th, notice of undocketed item. I attached the item that was undocketed. They filed the notice, and again, they did not file the undocketed item. So 2 times I've taken paperwork to the court and they did not file it. So I contacted the clerk's office, and so eventually they did file it, but defense for Apple used the delayed filing as a reason to dismiss or to deny my claim or whatever the case may be. So I suffered adverse actions because of the court's delaying of filing my motions, which is against the law as well. So ECF 192 was the motion the judge filed to withdraw my subpoena to Bonnie Hunt. ECF 194 was the motion that the judge ruled to grant Apple a protective order. So that shut down discovery for me to gain access to the claims of cyber intrusion. In the retaliation timeline, you can see there are videos where my phone, I would turn it off and it would turn back on by itself. So essentially this phone was like a tracking device. So anyway, so the judge made a couple of rulings preventing me from gaining information or evidence in discovery. So in ECF 309, the judge ruled to grant sanctions because I would not give defense counsel full access to my medical records. For one, defense counsel issued a subpoena to my therapist that was not signed by the court, which they cannot do. And they demanded access to all of my medical records. They cannot do that unless I sign an authorization, and that's through HIPAA. I did not sign an authorization. So they went behind the court's back, improperly served a subpoena to a therapist, which is technically witness intimidation, asking for all of my medical records with no dates on them. They have no reason to ask for full disclosure of my medical records. The only reason they gave is because I filed intentional infliction of emotional distress. That does not give you right to access all of my medical records. That's not the basis of my claim. I didn't say that I was traumatized or I couldn't work because of the intentional infliction of emotional distress. So they didn't give justification for full access, but the judge did not stop it. In fact, she supported it. So because I did not give full disclosure, she sanctioned me, which in turn, she requested that the full case be dismissed. But in turn, Judge Gergel, who makes the final decision, her ECF 309 was a report and recommendation, which the final decision is made by the district judge, which is Judge Gergel. He decided to dismiss my cyber intrusion claims, my privacy invasion claims, compensatory damages, and it was another claim. So basically any claim where I requested damages for cyber intrusion or privacy invasion, all those claims were dismissed based on Judge Gergel's ruling. That ruling was made on May 4th. May 9th is when my laptop was hacked. In May 26th is when my cell phone was hacked. So it's not a coincidence. These claims were dismissed, and then the cyber intrusion became more aggressive, and they hacked my personal devices. According to Judge Mary Gordon Baker in ECF 309, she told me that I was not allowed to present any more evidence. So you take away my ability to present evidence, and then after that, I encounter another cyber intrusion, which at this point, it's more aggressive. But because you said I can't present it and you dismiss those claims, I can't present it before the court. But I can present it on this website. So if you go through the judge's rulings, you'll see a pattern of bias, a pattern of disregard for the law, a pattern of irregularities when it comes to court filings, a pattern of disregard for the law and rules and regulations that are put in place to ensure fairness that's just not what's happening in this case. So sorry this video was a little longer, but it's the only way I could present the information in that section. So the judge's orders, it's in the Curtis Wright section, and take a look at it and you'll understand why this website was necessary. Have a good day.